Good afternoon, everybody. Thank you very much for joining us. Warm virtual welcome from 42. You join us today, so myself, Gillian Crew, and my colleague Nick, and we're going to be talking to you about the Com and Gulf International case. This is the latest of our employment group webinars. The title for the webinar is Not What You Say, It's the Way That You Say It, which really is a good summary of Com. How we're going to do this webinar is that I'm going to talk a little bit about some of the cases that preceded Com, and then Nick is going to fill you in on what happened in Com. But the reason we've called it this webinar is it's not what you do, it's the way that you say it. And it's and the question that we're asking ourselves this afternoon is, does the Court of Appeal decision in Com dilute the protection for whistleblowers? Now, I'm hoping to persuade you that I don't think it does. And even if it does a little bit, I think that from looking at the predecessor case law, in particular the case law generally in whistleblowing since 2013, that we will find a way that essentially the pendulum will swing back towards the genuine claimed whistleblower. I don't know whether Nick is going to agree with me on that second, but we'll have a look. So moving on to the first part. For those of you, I'm sure you're aware of the case of Com, but Miss Com was a lady who works the head of financial audit. She made a verbal protected disclosure about the industry standard financial compliance template, saying it was not suitable for the purpose that what it was using it for. She repeated that in an email and raised concerns about the head of legal's professional awareness. Now, I think those of us, the lawyers in the room, would probably say, well, that's never a good career move at the best of time. And it certainly wasn't for Miss Com. She was dismissed, and the case went all the way up to the Court of Appeal, with the ultimate conclusion that the reason for the dismissal was not the protected disclosure, but was the questioning of the head of legal's competence or integrity, which was not a necessary feature of her protected disclosure. That decision was greeted with some dismay by Protect, who, as we know, is a very worthwhile charity that has been set up to encourage safe whistleblowing. They issued a statement on the 8th of July. Well, that's a disclaimer, always good to remember the disclaimer. Blowing the whistle, there we go. And they said this. They described the case of Com as a worrying decision by the courts that means an employer can dismiss a whistleblower for the manner in which they raise concerns rather than the whistleblowing, even if those concerns were raised in a reasonable manner. They go on to say the court said that there are likely to be few cases where employers will be able to rely on upset or inherent criticism caused by whistleblowing as a separate and distinct reason. But Protect's view is that this judgment will cause uncertainty for whistleblowers and make it easier to victimize and dismiss whistleblowers. The law needs to change to strengthen whistleblowing protection. And the CEO of Protect, Liz Gardner, said, this judgment is very disappointing. We fear this undermines protection for whistleblowers. Whistleblowing law was established to encourage responsible raising of concerns about risk and wrongdoing in the public interest and to protect those who speak up from retaliation. Here, the tribunal agreed that Ms. Com had been a responsible whistleblower, raised her and agreed that her dismissal was not justified, but still she was denied whistleblowing protection and lost her automatic unfair dismissal case. It's often the case that whistleblowing will cause upset and very frequently leads to a breakdown in relationships. But to allow an employer to dismiss because the relationship broke down and to say that this can be entirely separated from the act of whistleblowing itself would send the wrong signal to unscrupulous employers. Employers should heed the court's ruling that there will be few cases where employers can rely on these distinctions. Nevertheless, we prefer greater clarity in the law. The current test for whistleblowing dismissal is too high a hurdle for whistleblowers to jump. Controversial, we'll see. So I'm going to have a look at whether, in relation to the predecessor cases, it's correct that somehow that the law has been protected, been diluted. And I said, my view is that I don't think that the Com decision actually changes that much. But what is important is to remember, in terms of whistleblowing, what we're dealing with and historical context. PIDA, the Public Interest Disclosure Act, was a short act of Parliament, came in force in 1999. It's one of those unusual cases because it's a private member's bill that was introduced by Mr. Richard Shepherd. And it was, although it was a short bill, it had big ideas. And the long title gives the idea of what the whole purpose of whistleblowing protection is about. It's an act to protect individuals who make certain disclosures of information in the public interest, to allow such individuals to bring action in respect of victimisation and for connected purposes. I said it was against the backdrop of some really serious disasters. So one that was close to my house, I grew up in the community, was affected by the Zeebrugge disaster, the Clapham Rail disaster, but also BCCI, Matrix Churchills, all cases which would have had where whistleblowing could potentially have prevented the ongoing events. So I don't propose to go through all of the blackletter law, as it were. What is the protection? Protection is, of course, under section 47B, right not to suffer a detriment, right not to be dismissed under section 103A, and of course the interesting one, the right not to be subject to a detriment by a colleague, a co-worker, under section 47B 1A, the vicarious liability under section 47B 1B. So in 2013, we know that in order to stem the tide of the kitchen sink type whistleblowing claims, and when I say kitchen sink, what I'm referring to is a case which we have all been involved in, where an employee does not have sufficient continuity of employment, so they seek a way to bring a claim and get the potentially use whistleblowing as the avenue to the tribunal. Particular problems arose as a result of Parkinsonic, so that the breach of the legal obligation can be the contract of employment. So it became a bit of a kitchen sink remedy. So the 2013 amendments, reasonable belief that disclosure is in the public interest and good faith is essentially relegated to remedy. So when we're considering how case law has looked at and has affected the protection, I'm going to suggest that even from the very beginning, the case law has always been very much favourable, thanks to the sterling work of the UK employer community, to genuine whistleblowers. So we know that there's the extended definition of worker, which applies to whistleblowing claims. We know that there is a wide net that is cast for people who can bring whistleblowing claims now. Also, we know includes judges now, following the case of Gillian. Not everybody's in there. I put there on the slide. So, for example, the vicar in Sharp was not included, sadly. So, whistleblowing, you see there on the slide, see no evil, hear no evil. It should be speak no evil, but obviously in case of whistleblowing, what we actually want is them to speak a lot and to be very clear about what they're saying. And that's the point really of that slide. So, the 2013 amendments in case law, after those amendments, I think they've also been pretty much in favour of claimants generally. So when it comes to, for example, disclosure of information, the subsequent case law that we had from 2013 will, of course, recall that we started off with the Gedald and Cavendish Munro case, which seemed to be more in favour of the claim of the respondents, namely that there must be a disclosure of information, not just an allegation. You'll also recall the case of Good, where an allegation or an opinion was not sufficient to be that disclosure of information under section 43B. But again, over time, we see a bit more, I guess, just a little bit of a row back. So the cases I put there of Kilrain and London Borough of Wandsworth, and also the Eiger Securities and Caution Over. The appeal courts, the Court of Appeal, really calling for a more realistic approach. So accepting that these things are always fact sensitive, but the information will be intertwined with allegation, that they often go hand in hand. And the useful quote I always think of is the Kilrain case. The Court of Appeal says, I would caution some care in the application of the principles arising out of Cavendish Munro. The dichotomy between information and allegation is not one that is made by the statute itself. It would be a pity if tribunals were too easily seduced into asking whether it was one or the other, when reality and experience suggests that very often information and allegation are intertwined. The decision is not decided by whether a given phrase or a paragraph is one or rather the other, but is to be determined in light of the statute itself. The question is simply whether it is a disclosure of information. And I think that that's a key point for me for this webinar, because what all of the cases circle back to and invite us to consider is the wording of the statute itself. IGA Securities again emphasised this point about intertwining of information and allegation. More in favour of the claimants. We know that the legal obligation itself doesn't even have to exist. The Babula and London Borough of Waltham Forest College case from 2007 is good authority for that. Also the Karachi case. There's no requirement the legal obligation itself exists. It's the objective reasonableness of the employee's belief that is so important. So leads us on to aggregation of disclosures, also very much in favour of the case law, also very much in favour of the genuine whistleblower. So the Norbrook Laboratories and Shaw case, you can look at a series of complaints to analyse whether there's actually a qualifying disclosure has been made out. More recent case of Simpson and Cantor Fitzgerald 2021 case. The aggregation of communications is a matter of fact. In that particular case, it wasn't actually successful because there was 37 communications and none of them amounted to protected disclosure. But what is key from that case for me is that, again, it's being emphasised that there's been no gloss put onto the words of the statute. And that the key is to go back to look at PIDA itself, to look at the statute again, and we're reminded there's no rigid dichotomy between information and allegation. In order for a communication to be a qualifying disclosure, it has to have sufficient factual context and specificity, such as to be capable to show it's one of the matters listed in 43(1)(b). And that's a matter for the tribunal. I just wanted to put as a final case on the slide the case of Twist and Arms, because I think this is an interesting illustration of where we are in relation to case law being favourable, I would suggest, to the genuine whistleblower. This was a case where Twist had raised general concerns at a US conference and then made 7 disclosures in months following the conference. There was sufficient specificity and factual context to show one of the matters in section 43(b). And what comes through from the judgment of the EAT on that is that the EAT make it clear that the provisions should be interpreted so as not to be onerous requirements on the worker to qualify for protection or to introduce technical requirements which, if unfilled, would leave them exposed despite public interest motivation. And I'm going to suggest that that is the tide, and that's going to be the tide in which Kong is ultimately going to float along. So we then look at public interest. And again, in relation to the public interest case, so I'm going to suggest that the tide is again pretty favourable to the genuine whistleblower again. Think of the case where we were with Chesterton's case. We know now, don't we, that we actually, the public interest, it's the reasonable belief of the employee in question. It's a fairly low bar for claimants to establish. So Chesterton case, Mr. Nur Mohammed was alleging that Chestertons were manipulating their accounts, affecting bonuses for 100 senior managers, made disclosures about this to Chestertons. Court of Appeal held that the essential point was that public interest had to serve a wider interest than the private or personal interest of the worker making the disclosure. They identified the 4 relevant factors to be weighed in the tribunal's analysis. So they looked at the numbers in the affected group, they looked at the nature of the interested affected, the nature of the wrongdoing, the identity of the wrongdoers. We then know in the Underwood and Wincanton case, the EAT looked at that decision and again made the point that public interest element, it's wrong to conclude the public interest element is not going to be met where the disclosure actually only concerns a small number of employees, the same employee. That was the case where the Underwood had a concern in relation to some of the overtime work with other drivers. So, and the EAT held that, to my mind, what leaps on the page is firstly the importance of the matter being assessed in a factual context. Secondly, the fact the EAT has held that public interest requirement may be met by a relatively small group of persons. And thirdly, those persons may constitute employees of the same employer who have the same interest in the matter as that raised by the claimant personally. I've also put the Dobie case, which is one of 42's own Susan Chan representing in that case. And that was another case where the EAT held the tribunal had erred in applying the Chesterton test. They hadn't addressed their minds as to the 4 factors. That it was doubtful that the appellant held a genuine and reasonable belief that the disclosure was in the public interest needed to be part of the motivation itself. I'm not going to spend too much time on these cases. I want to get on to the predecessors to Con. But what I would suggest is that it shows that when the case law develops, the way that the case law is developed tends to be relatively favourable to the genuine whistleblower. So we know on causation, that's the real fight, isn't it? We know we have the detriment claims under section 47B. They have the test, as it were, of material factor, and it's the Feckett case of that. The unfair dismissal case, we know, is the sole or principal reason. That seems to me is always the crucial fighting ground. And yes, there is a significant discrepancy, but it's there in the statute. And the Wyeth case that I've referred to on the slide tells us exactly that. The Sainsbury's, the Salisbury NHS Trust and Wyeth says this: I accept that this creates an anomaly. And it goes on to say, in my judgment, the better view is that section 47B will be infringed if the protected disclosure materially influences, in the sense of being more than a trivial influence, the employer's treatment of the whistleblower. If Parliament had wanted the test for standard of proof in section 47B to be the same as for unfair dismissal, it could have used the same language, but it did not do so. So in other words, in relation to dismissal, it remains the reason why question, not the material influence of the sole or principal reason. Now, of course, Nick and I were discussing this before we came on air, as it were, and it's extremely unlikely, isn't it, that Parliament would actually be applying its mind to the standard of proof that was going to be applied in tribunals in relation to the difference between detriment and section 103 claims. But there we go. What I do say in relation to the causation case is that even in relation to causation, there is a line that can be traced of favourable decisions in relation to the genuine whistleblower. So think Timis and Osipov. Think about the detriment claim and the fact that losses suffered for dismissal in consequence of dismissal can still be claimed where the claim is made against an individual co-worker under section 47B 1A, for which an employer will be vicariously liable under section 47 1B. So that obviously has the material influence case. Think also about the duty case. So where the decision maker adopts an invented reason. In this case, it was the absence of dismissal, where a manager in the hierarchy of authority was motivated by the protected disclosures to dismiss. The real reason is the hidden reason, the protected disclosures, and not the invented reason of absence, even though the dismissing officer wasn't aware of that hidden reason. So that leads me nicely on to the separability principle in the early years. So if it does look like the protected disclosure is in play, we consider separability, we consider separability principle. Is it possible to separate out that awkward protected disclosure from whatever the detriment or the dismissal is? And there were numerous cases in between 2007 to 2014 that lead up to Con that I think we've all become quite familiar with, and have indicated that that was on the wording of the statute entirely a feasible option, because of course the statute and the causation test asks us to look at the reason why. The first case that I'm going to quickly go through is the Bolton School and Evans case. This was a teacher who was given a disciplinary warning, you'll recall, for hacking into the school's computer in order to demonstrate that the school's security system was a bit rubbish. He wasn't very impressed with that, and he resigned, claimed constructive unfair dismissal. He's successful at first instance because the tribunal found that the reason for disciplining him was his conduct in entering the system in the way that he did, i.e. hacking it, and his conduct was part and parcel of his disclosure. But the EAT disagree. Essentially what they conclude is that the protected disclosure was the means by which his misconduct was found out by the headmaster. But the question under the Act is, of course, the reason why. Why was he, in that case, disciplined? He wasn't disciplined because of the protected disclosure, he was disciplined because of the misconduct. And the tribunal have made clear findings that his conduct in entering the system the way that he did and hacking it that led to his warning and not his protected disclosure. So that was an early example. And then we get to the possibly the more familiar cases of Martin and Devonshire, and then Paniatu and Chief Constable of Hampshire. These are cases where previously we might have argued and said, well, we've got the protected disclosure, but it's not been raised in a particularly reasonable way. So in Martin, the claimant presented grievances to her employers about various matters complaining of harassment and victimisation. Those grievances were all investigated and they were found to be without base. Disciplinary proceedings were pending against her for making false allegations. She takes a leave of absence and becomes sick, and she puts in further grievances about discrimination and victimisation. Interesting enough, in relation to the Martin and Derbyshire case, it's actually found that some of her complaints were probably auditory hallucinations as a result of being ill. But there we go. The employers dismiss her because they take the view that relationship breakdown had occurred. So even if she returned to work, she would carry on raising grievances against all of the partners and she wouldn't let matters go. So essentially in Martin, the allegation is that she may be raising matters, but she's raising them in an unreasonable manner. So it's that leads to the separability argument. And in Martin, it's accepted that argument can be made. There can be a distinction legitimately made in some cases between the complaint that is made and the way it is raised. So it's said in the Martin case, and it's accepted that it's possible for this argument to be abused, but it said, the most straightforward example of this is where the reason relied on is the manner of the complaint. Take the case of an employee who makes in good faith a complaint of discrimination, but couches it in terms of violent racial abuse of their manager, alleged to be responsible, or who accompanies a genuine complaint with threats of violence, or insists on making it by ringing the managing director at home at 3 o'clock in the morning. In such cases, it's neither artificial nor contrary to the policy of the anti-victimisation provision to the employer to say, I'm taking action against you, not because you've complained of discrimination, but because of the way in which you did it. So in other words, back to our title, it's not what you say, it's the way that you say it. It was accepted in that case that, yes, that could be open to abuse. But employees who bring complaints often do so in a way that, viewed objectively, can be regarded as unreasonable. And it would be contrary to the policy of anti-victimisation provisions if employers were able to take steps against employees simply because in making a complaint they had, for example, used intemperate language or made inaccurate statements. So it's clearly not an open door for employers to be able to do whatever they want to somebody just by saying, well, we don't like the way that you're doing this. The Martin case was not followed by the next case, which is the Woodhouse and West Holmes. And in fact, in that case, they said that the successful arguments of separation should be exceptional. So distinctions between complaints and the manner of making complaints should only be drawn in clear cases that the instant appeal was factually well short of the kind of exceptional circumstances exemplified by the factual matrix of the Martin case itself. Enter Paniatu. Paniatu was an officer in the Chief Constable of Hampshire's force. He made protective disclosures to senior officers about the attitudes of certain officers, treatment of race and victims of rape, child abuse, etc. Following an investigation, his concerns were actually largely upheld, but he was unhappy with the outcome of the particular case he'd raised. And again, he wouldn't let it go. He sought to right the wrongs that he believed had occurred. He campaigned for the police force to take more action than they believed to be appropriate. He took up huge amounts of management time and raised various grievances about it. So essentially he became unmanageable. And he also spent a lot of time at home on sick leaves. So unfortunately, that led to him being recommended for dismissal, and he brought a claim of being subject to detriment. In short, he'd become completely unmanageable, and that led to the distinction being drawn between his protected disclosure and his conduct. And in Paniatu, the key point is as follows: as the EAT in Woodhouse suggested that such cases would only be exceptional, that the detrimental dismissal would not be found to be done by reason of the Protected Act. There was no additional requirement that the case should be exceptional. Go back to the statute. In the context of protected disclosures, the question was whether the factors relied upon by the employer would properly be treated as separable from making protected disclosures, and if so, whether those factors were the reason why the employer acted as he did. Tribunal would bear in mind both the importance of ensuring that the factors relied on were genuinely separable and the observations in Martin in relation to not abusing the separability argument. The tribunal had drawn a distinction between the factor making the disclosures and other features of the situation which were related to but separable from the fact that the claimant had made protected disclosures and it was permissible to do so. So this leads us into where we, the situation related to Con. The cases I think that we are looking at now that predated Con generally concerned cases where the protected disclosure had not been raised in a particularly reasonable manner. So think about Mr. Evans hacking the school. Think about Miss Martin and the various grievances that she made. Think about Mr. Paniati not letting it go and becoming unmanageable. They may have had good points, but the good points were lost to the employer and action taken against them because of the way they conducted themselves. Miss Kong would argue that she's in a different boat altogether, but I'm going to suggest to you that looking at the case law, we can see that the thread, certainly as far as policy is concerned, is to try and remove so far as possible any of the technical barriers. And to make, it seems to me that as case law has developed, it does become more favourable to the genuine whistleblower. If I'm wrong about where I'm going on Con, I'm going to suggest to you in the awesome words of Jeff Goldblum that life finds a way. And in this case, I'm going to predict that PEDA will find a way in relation to Con. Over to you, Nick.
Thank you, Jill. A lot has been written about the implications of the Court of Appeal's judgment in Kong, but it would be useful to look in closer detail at Kong at first instance. There are a number of interesting practical points that come out of the case, and a bit like this image I've attached of two eyes from one of James Cameron's Avatar creations, the case gets a little bit stranger, I suggest, the more you look at it. And that's why overall I will be saying that Kong is not the threat to whistleblower rights that it might at first appear to be. So the first slide I want to introduce is essentially going through two of the main features of Kong. The first one is that this case was always all about causation. The claimant worked in the role of the head of financial audit, and it was her job to carry out risk-based audits. It was inevitable in her role that lots of her communications would amount to protected disclosures. In reality, her job really involved her making protected disclosures almost all of the time. And the respondent conceded at the start of the hearing that the claimant had made a total of 10 protected disclosures as she had pleaded it, including one of them that she had been automatically unfairly dismissed on the principal ground of whistleblowing. So the starting point of the case looked very strong. The respondent had conceded that she'd made disclosures. Often that's a difficult feature of a case to prove the individual has made a qualifying disclosure in the first place. But this actually introduces an interesting distinction. So sometimes in a case, an individual won't be making disclosures in their workplace really at all. Then they suddenly do, and they suddenly experience problems at work. But there are many individuals, whether they're in a medical context, a financial context, or they're trade union representatives, that sort of role, where actually they are regularly and frequently making protected disclosures, and that can actually become a weakness for them as a claimant. The respondent can say, well, we've been receiving protected disclosures from this claimant for many years, and we haven't reacted adversely on those occasions, but on this occasion there was something different. And then they can point to the particular impact that the manner of communication has had, or some other personal dynamic, which is essentially what is relied on in Kong, to explain why it had the particular effect it did. So from the point of view of a claimant, if they are someone who is frequently making disclosures and they want to prove that there is something about these disclosures which has caused the adverse reaction, as opposed to their run-of-the-mill information they're communicating which would otherwise qualify, then they may want to try to rely on something special about the subject matter why would these disclosures have been particularly frustrating or expensive or otherwise antagonizing to the employer? So that's one issue to bear in mind about Kong. It was always about that narrow question of causation. The second point is that winning either of these whistleblowing heads of claim would have been very valuable. The claimant had a schedule of loss of some £2.6 million. There doesn't seem to have been any real dispute that there was a falling out between the claimant and the head of legal within the organisation, so reinstatement, re-engagement wasn't a real possibility. The statutory cap for loss of earnings doesn't apply to section 103A, and it doesn't apply to section 47B. And after Timis and Osipov, we know that dismissal pleaded as detriment can be pursued, so that compensation in respect of loss of employment can even be pursued against a fellow worker. So those whistleblowing claims were where the value was. No, they're not. I'll move on to the next slide. And the claimant did try to bring a claim of dismissal as detriment, but she was found not to have done so. And although Kong generally is reported and described as undermining the protection offered to whistleblowers generally, in reality, the case at appellate level concerns only section 103A, the automatically unfair dismissal claim. The claimant isn't able to pursue her dismissal as detriment, the 47B claim, because she's found not to have brought it. And in order to bring it, she's required to then amend her claim to bring a claim that a particular individual has subject to her to the detriment of dismissal, and that the respondent is vicariously liable for the conduct in question. The claimant sought to amend her claim on the first day of the hearing to bring that separate claim. But of course, the tribunal was very likely to refuse that. In their reasons, they expressly have regard to the fact that the causation test is easier for 47B, as we know from Fessett. It's the material influence test, whereas section 103A is more difficult. The sole or principal reason means that a tribunal is always going to be compiling effectively a list of reasons, if there are more than one, and then seeing whether it is the whistleblowing that comes to the top of that list. It's a more difficult proposition to win that claim. And so the claimant, in not being allowed to continue that claim, ended up being in a very different position. The problem for the tribunal is if it did allow the claimant's amendment, there would be a potential £2.5 million claim against an individual. And also, the respondent hadn't been on notice of that way in which the claim was going to be put. And so the respondent would not have been able to prepare the reasonable steps defence in respect of those individuals, or to take instructions on the same. So that's the relevant background. There were some detriment claims, it's fair to say, but they, as I say, they don't concern the actual dismissal itself, and they don't relate to any of the decision makers who actually made the decision to dismiss. So turning to the facts of the case, the claimant was very, very good at what is objectively a difficult job, but many former and current employees of the respondent who gave evidence to the tribunal said that her performance from a technical perspective was outstanding, her work ethic was extremely good, but she was also described at times as playing off members of the team against each other. A number of her reports were very lengthy and complicated, and some felt that she was sometimes unable to see the wood for the trees. So the claimant had some background of creating friction within the workplace. On the particular facts that led to her dismissal, the claimant had provided a draft audit report. She'd raised a large number of matters in there, which seems to have been essentially her habit. A reply was provided to her by the respondent's head of legal, Comments were attached to that audit report from the legal department, and significant deletions of parts of that report had been made by Miss Harding. Miss Harding also stated that a document the claimant had referred to, the MRPA, was not a bank-to-bank document. That turned out to be incorrect. The claimant sent an email essentially asking why such an unusual approach had been taken and about the deletions to the report, that this wasn't the usual way her draft reports were addressed. And the tribunal recorded that Miss Harding felt a degree of sensitivity about the way she had handled this, and did think perhaps that what she had done with the draft report would not reflect well on her. And so this was part of the reason that she reacted as she did in the conversation with the claimant. And I think just to note there, where there is another reason for conduct, where there is another reason for the treatment of a whistleblower, it doesn't necessarily have to be a particularly good reason, as long as it is a genuine reason. I'll come back to that later on. But what the tribunal is doing here is they are providing a very detailed analysis of exactly what happened during these material events. And because of the nature of the claimant's work and the nature of the audit, all of it amounts to a series of whistleblowing disclosures. But that doesn't seem to be where the core of the case lies, but we'll come back to that. After the claimant had sent an email to Miss Harding, essentially challenging her approach, Miss Harding then goes into the claimant's room and they have a conversation, in the course of which the claimant questions the legal awareness of Miss Harding. And Miss Harding leaves the room and she is upset. There's a conversation with the respondent's head of human resources about that conversation, and the tribunal recorded that head of human resources, Miss Yates' impression that Miss Harding had reached the end of her tether with the claimant. And then a further email is sent by the claimant, which is blind copied in to Mr. Mohammed, who's the group chief auditor, in which the head of legal's legal awareness is again questioned. And essentially what follows is a breakdown in the relationship between the two individuals, and Miss Harding is essentially not prepared to work with the claimant anymore. Miss Yates drafts a recommendation document, and there's a meeting with the CEO, Miss Garrett Cox, and Mr. Mohammed, and they recommend dismissal effectively to him and to the CEO, and they agree to dismissal. So that's a rough and ready summary of the facts, and it's quite obvious that without the claimant's actions in whistleblowing, Miss Harding would not have become upset, and Miss Harding would not have had that exchange with the claimant, and would not have been in a position where she had to go to head of human resources, who would then not have made that recommendation to Mr. Mohammed. And just before we look at the reasoning for the findings the tribunal makes about the separate decision makers for the decision to dismiss, it's worth noting that there was a detriment claim that could have succeeded against Miss Harding, but it was out of time. The tribunal found the behaviour of Miss Harding toward the claimant was a detriment and was materially influenced by the protected disclosures. They found that she went to the claimant's office without making an appointment and in an agitated state in response to the claimant's email, in which the claimant suggested that Miss Harding had delayed dealing with and deleted large parts of the document containing a protected disclosure. Miss Harding became more agitated when the claimant raised a further disclosure in that meeting, and she walked out and slammed the door. She then told a number of people in the office about the incident, including two people involved in the ultimate decision to dismiss, Miss Yates and Miss Garrett Cox, and wrongly said that the claimant had questioned her professional integrity and the nature and extent of Miss Harding's complaints to others about the claimant was a material part of the reason why the claimant was ultimately dismissed. Now, that detriment claim was out of time. And as I say, there was not ever a claim that the dismissal itself amounted to a detriment. The tribunal addressed the reasons for the decision, and effectively they applied the Supreme Court authority of duty to find that this was not a case in which the decision was so tainted that it followed that liability should be fixed. So there were three main elements to that decision to dismiss, and the first one of those was that none of the decision makers were found to have been motivated by the claimant's protected disclosures when taking the decision to dismiss. And the tribunal made a surprising factual finding in context that none of them looked in any way at what had led up to the incident with Miss Harding or at the underlying issues that were of concern to the claimant in her protected disclosures. This is surprising because we might well say that any person working in human resources wouldn't want to know what the content of a disagreement was about in order to be able to assist. And we might well say that given their respective seniorities, that Miss Garrett Cox and Mr. Mohammed would have fully understood the underlying issues. And I will come back to why, in context, that finding seems more likely than not to be correct, but I'll come back to that later. The second point the tribunal made was that the reason for the dismissal was the claimant had questioned Miss Harding's legal awareness and that Miss Harding was upset by the same. And although Miss Harding and the decision makers used Miss Harding's language, which was to the effect that the claimant had questioned Miss Harding's integrity instead of her professional awareness or her legal awareness, this did not engage the principles in duty. So there are two things that are worth saying about that last point. The first is about the limits of duty, which I'll come to in a moment. And the second are the particular facts of the case relating to, essentially to how Mr. Mohammed had gone about his decision with the other two individuals together. So on the facts of the case, buried in a long judgment, it must be said, Mr. Mohammed had worked with the claimant for some considerable time. There had been conflict with previous members of staff between the claimant and them, and in the end, the claimant had been supported. Her view of a very technical matter was ultimately supported by Mr. Mohammed. That's the approach that the respondent adopted. And so when he says that he was only motivated by the working situation, it seems very likely he's going to be credible. He didn't seem to have an issue with the claimant disagreeing with anyone and everyone. His issue seems to be where it had caused upset with a senior employee. The head of legal is obviously a very senior position. And so this is where the case looks more unusual the more you look at it. And when we think about cases employers are going to face, it means that a strength for an employer is to be able to say, in the past, we have had frank conversations with X or Y trade union representative, we've had X or Y conversation with this or that doctor disagreeing about this or that, but we haven't taken against them. And the uniqueness of the instant situation then does start to look like the personal dynamics in an employment relationship, instead of the uniqueness being the nature of the disclosure. And I think that was the issue that Ms. Kong was really up against, was that she had a history, in effect, of being supported when she disagreed with people. But she did have a history as well, building up ill will with a range of individuals for how she dealt with people. The second point is about the limits of duty. So as is well known, in the case of duty, effectively, Lady Hale explained the rationale, but where a person in the hierarchy of responsibility above the employee decides that for a reason, being the making of protected disclosures, that someone should be dismissed, but then they hide that reason, then even though a perfectly innocent decision maker adopts that recommendation, that the courts have a duty, in effect, to see behind that sham reason. In the instant case, there was no fiction in Kong. Miss Harding was upset, and Mr. Muhammad and Ms. Yates and Ms. Garrett Cox, they believed that to be the case. So Kong was always going to fall on the wrong side of duty, because this wasn't the case where there was any kind of deceit. And so in a way, Kong highlights the narrowness, if you like, of duty. And then turning back to the Court of Appeal's decision, Lady Justice Imler gives a very clear definition of the separability principle, emphasising it's not a rule of law or a basis for deeming an employer's reason to be anything other than the facts disclose it to be, and indicates it's a label that identifies what may, in a particular case, be a necessary step in the process of determining what, as a matter of fact, was the real reason for impugned treatment. And in a way, it proves the old cliche that hard cases can sometimes appear to make bad law, in that Kong is now cited as an example of where whistleblowing rights have been eroded. But in the head notes of Kong is a record of the emphasis from Lady Justice Imler that there are likely to be few cases where employers will be able to rely on upset or inherent criticism caused by whistleblowing as a separate and distinct reason for treatment from the protected disclosure itself. That's quite a chunky statement, but just to unpack that, what that means is in reality, where an individual receives a negative reaction to protected disclosures, merely being upset by the subject matter of what is said is very unlikely to avoid liability. What happened in the instant case is there were a number of factors which helped the respondent. There are some very difficult questions that could arise from the case. What would have happened if the detriment claim had been live and had been essentially dismissed on the same basis or similar basis to the Section 103A claim, that disclosures weren't in the minds or affecting the minds of any of the decision makers whatsoever? That then, if that had been live, I think Kong would be a more difficult authority than it in fact is. And the very last thing, slide I've put up is another another image of a four-eyed creature from Mr. James Cameron's world, to point that looking at things in more detail can also be a relaxing thing, because the reality is that before Kong, it was generally considered that that sort of defence was difficult but worthwhile, and I would say that actually that should be the approach after Kong as well. Does that nicely lead us into some questions?
I think it does. And I think the first question I have to ask myself is that clearly I need to go and watch Avatar 2 because I'm behind on the sides. I think looking at that point that you just made, Nick, about if the detriment case had been live, you think it would still have been the same result? Because I think on the facts that you're describing, if you're looking at the material influence, it would have been a pretty good argument, wouldn't it, to say Mrs. Harding had taken against the allegation made against her, she saw it as an attack on her professional integrity. There would be an argument that that had gone into the SOZA and the breakdown. So it would have been a stronger argument to make there was a material influence there.
Yeah, I think that is right. I think the tribunal itself, I think, had in mind that the claimant really, with what she was sending in the audits, that there was nothing particularly special about what was in this audit. That in effect, as far as Mr. Mohammed was concerned, the claimant was just doing her job. But in the course of doing that, she had been difficult and she'd upset someone. So I think the tribunal, I suspect, would have still dismissed the claim. But I think on appeal, I think the appellate courts would have been much more likely to have overturned that decision on the detriment claim. And I think it would have been a much stronger claim on a detriment as dismissal claim. And I mean, it's a difficult point. I think the material influence, though, in Fessett ultimately does apply to the mindset of the decision maker. And if the decision maker is totally indifferent to the fact that this arose in a whistleblowing context, which for someone who, as I say, the high level of technicality of what this claimant was doing meant she was basically whistleblowing all the time. It's probably one of those rare cases where you could say maybe this employer genuinely, those decision makers genuinely, they didn't mind the context this came out in. But I think it's a much more difficult case.
It is more difficult, isn't it? Because the previous cases that we've looked at before, so the Martin and Devonshire's, the Paniati case, that's all about the unreasonable person. But clearly Miss Coleman, on the facts that you've just described, she's not being unreasonable, is she? Other than, obviously, Miss Harding would say, hang on a minute, she has been unreasonable because she's questioned my professional competence and my professional awareness. But it seems to me that don't we still end up at the same place, that we're asked to look again at the statute? So what Similar is saying is that you go back to, you look at the reasons, what was the reason for, the reason why, and it's not because of the protected disclosure.
Yes,
it's because of the other features.
I mean, there were some other things, and I think certainly, it is a long judgment. I mean, the claimant was given the opportunity to apologise, and she didn't do it. It sounds like the previous topic which I referred to, that Mr. Mohammed believed the claimant and the respondent adopted this quite major approach, which was championed by the claimant. That indicates that Mr. Mohammed had a very high tolerance for the claimant simply disagreeing with people. He didn't really mind that at all. He's looking at a good outcome. He doesn't really mind overly how he gets there. But the head of legal was a very important member of staff. And I think ultimately, the test is looking at the mind of a decision maker. The decision maker is only a human being, as it were. And if the tribunal finds, as a matter of fact, these particular humans, they weren't interested in the hows and whys and wherefores of how this argument came about, they've just got a very senior employee who's very upset and has been questioned, and they have taken the view, rightly or wrongly, that shouldn't have happened. And I think to an extent you're at the limits then of where as a matter of policy, maybe maybe the appellate, this is where the appellate courts will say, well, if that's what the findings are, that's what the findings are.
But do you agree, Nick? Because one of the questions is about what Similar has said about there are going to be few cases. It seems to me that this case does not open the door to saying, right, well, we don't like what you've said, therefore our relationship is broken down, therefore you're out, and that's a separability issue. It seems to me that is not going to be an open argument. Yes,
I think that's right. So I think this particular employer in some ways did behave quite unusually in other contexts as well. So they didn't adopt any real process for dismissal. They simply told the claimant she was dismissed, and that was that. So they were a slightly unusual employer. I think for looking at other cases going forwards, the key issue is always going to be what is going through the mind of the person when they are making that decision to dismiss. There wasn't a perversity appeal, as far as I'm aware, about what was considered by those individuals. The claimant did represent herself at the final hearing, so I don't know whether that has impaired the ability to bring in a more fact-based appeal, but perhaps the subject matter of the disclosures was in their mind. But yeah, I think it will be a rare case that can successfully apply CON.
Yeah, I do think so, Nick. Would you agree as well that it's likely to be the case, or at least perhaps my breadcrumbs are a little bit too obvious, that it's likely to be the case that we will have something going through the appellate system exactly on those rare cases, and the outcome will be no, the limits have been met in relation to CON, not going to go any further.
I'd be very interested to see those cases. I'd be very, very interested to see a 47B detriment dismissal case.
I think on the detriment dismissal case, that would have been, I personally, I think it might have had a different outcome, but it was clearly right on the facts that it didn't get through, because you can't turn up to the first day of a full merits hearing and face a completely different claim with the statutory defence, etc. So I can see why it didn't succeed, but had it been argued, it seems to me there might have been a stronger case. We might have been having a slightly different discussion. But I certainly think going forward, when it comes to these cases, separability is going to continue to be a difficult argument to have, but it all comes back to the statute. It's looking at the reasons, and if the reasons can be separated somehow from the protected disclosure, there's been no reason in the past why that can't be done. There's no reason in the future. It's made a little bit more difficult, it seems to me, in the distinction with Kong, isn't it? It's a fairly reasonable case about the way it's raised, but nonetheless, it's simply applying the statute.
Yeah.
Okay. Yeah. Okay, well, I think that is all of the questions that our people had for us. So thank you very, very much for joining us. The webinars will be back next month. I'm afraid I have to hang my head in shame a little bit. I'm not sure what we're talking about next month, but I know it'll be brilliant, and I know the speakers will be awesome. So please do join us when we let you know what that is about, and you'll see the advertising for that. But thank you very much for your time. As I said, I'm off now to watch Avatar 2 tonight. Thank you for your time. Thank you.